Thank you, Mr. Chairman. At the beginning, I'd like to enter into the record a statement from the senior senator from Texas, Senator Cornyn.
Of course. Phillips, objection.
I'd like to thank each of the members of the panel for being here, in particular Ms. Fulton and Ms. McBath. Thank you for being here. Thank you for sharing your stories. Every parent understands the mourning you are feeling, and it is always a tragedy when a child loses his life. And please know that we are all feeling your loss and express our very sincerest condolences. Much of the discussion this afternoon has concerned the tragic circumstances of the Trayvon Martin case. And none of us in this hearing room were there that night. None of us knows precisely what happened. We do know that there was a violent altercation between an Hispanic man and an African-American teenager. And we know that at the end of that confrontation, the teenager was dead. What exactly occurred that night, no one in this room likely will know for sure. But we do know some things. We know that our system of justice has a process for ascertaining what happens when there is a violent confrontation, particularly one that leads to the loss of life. And that process is a jury trial. And a jury of Mr. Zimmerman's peers heard the evidence in that case. He was prosecuted in that case. And the jury rendered a conclusion. We don't know if the jury was right or wrong, but we do know that the jury system is the only system that our judicial system has for ascertaining what happened, particularly when you have a one-on-one confrontation. It can be particularly difficult to determine what the facts are. But we also know that the subject of this hearing, the stand your ground laws, was not a defense that Mr. Zimmerman raised. So this entire hearing, the topic of this hearing is not the issue on which that trial turned. And sadly, we know that some in our political process have a desire to exploit that tragic, violent incident for agendas that have nothing to do with that young man who lost his life. We have seen efforts to undermine the verdict of the jury, and more broadly to inflame racial tensions that I think are sad and irresponsible. I recognize that for the family, you're simply mourning the loss of your son, and I understand that. But there are other players who are seeking to do a great deal more based on what happened that Florida night. I would note additionally that the chairman of this committee a moment ago made I thought, remarkable statement that to the effect that no one could reasonably believe that stand your ground laws protect those in the African American communities who are victims of violent crime. I think that's a remarkable statement on many, many fronts, including the fact that a great many African Americans find themselves victims of violent crime and have asserted this defense to defend themselves, defend their families, defend their children. But I also find it remarkable because the assertion that no one reasonably could suggest this benefited the African American community is drawn into remarkable relief when one keeps in mind that in 2004, a state senator in Illinois by the name of Barack Obama co-sponsored an expansion of Illinois' law providing civil immunity for those who use justifiable force to defend themselves. So the notion that stand your ground laws or some form of veiled racism may be a convenient political attack, but it is not borne out by the facts remotely. I want to secondly note the issue of ALEC, an organization that exists to encourage common sense legislation in state legislatures. I would like to enter into the record multiple letters that have been submitted to me by organizations that are concerned about the targeting of ALEC in conjunction with this hearing. And I would note that it should always be a concern when you see the United States Senate targeting the exercise of free speech. This observation is not unique to me. Indeed, on August 8, 2013, the Chicago Tribune wrote an editorial that stated free speech isn't always free. It gets downright cumbersome when senators have you on their enemies lists. And it would be wrong for a U.S. senator to use the power of his high federal office as a cudgel against his enemies. And I certainly hope that this Senate hearing does not become an avenue to suppress free speech. A final point I'd like to make. By its definition, the Stand Your Ground law does not apply to aggressors. It explicitly excludes aggressors. I would note, Ms. McBath, on the facts as you've described, that evening your son lost his life, the defense would not apply, would not even arguably apply. It is a defense that only applies to those who are the victims or potential victims of other violent aggressors. Indeed, it is only triggered when there is, quote, an imminent attack that could cause death or serious bodily injury. So this is a doctrine that by definition does not apply to aggressors and only applies when death or serious bodily injury is at risk. And so the question that all of us have to ask is, in a confrontation between a violent aggressor and a potential innocent victim seeking to protect himself, herself, or her children, with whom do we stand? And I, for one, believe we should stand with the innocent against aggressors. That is why the right to self-defense has been so critical for time immemorial. And I hope that we will not see the constitutional rights of innocent citizens sacrificed because of political agendas of some. Thank you.
I'd ask patience of my colleague from Connecticut, since Senator from Texas has raised some personal issues. I'm going to respond to him. Let me be very specific when I say this. Don't take my word for it. Take the testimony of Hillary Shelton, director of the NAACP Washington Bureau, in which he states, and it's part of this record, few issues have caused as much angst and raised as many deeply held concerns among our members and the communities we serve as that of Stand Your Ground laws. These laws and their applications have sadly resulted in no less than the murder of people who were doing nothing more than walking down the street. The statement in the record by Hillary Shelton of the NAACP. This continued reference to inflaming racial tensions, my friends, we've heard this before, over and over again. We have problems with the issues of race in America that we have to face squarely. And when people are being discriminated against, whoever, wherever in America, the Subcommittee on the Constitution, Civil Rights, and Human Rights is not going to back away. The second point I'd like to make is this. There are many victims when it comes to Stand Your Ground laws. ALEC isn't one of them. I will concede that I asked those who were publicly identified as supporters of this organization if they supported this Stand Your Ground law. Only one out of 140 that responded said they supported it. I'm not going to enter the names of these organizations in the record for the very point that was made by the senator from Texas. I don't want to establish any chilling effect on political participation, but I think it is reasonable to ask the members of an organization if they agree with that organization's agenda, an agenda which Mr. Piscopo, who is now the chairman of ALEC from the state of Connecticut, has said they no longer stand by. So I'm not going to enter any names into the record for that very reason. But isn't it noteworthy that out of 140 organizations contacted, only one said they supported ALEC's agenda on stand your ground laws? That's fact. Senator Blumenthal.
Thank you, Mr. Chairman. I want to thank the chairman for having this hearing. It is not only a legitimate, but a necessary hearing. It is profoundly important that we face these issues of human rights, which hopefully are also matters of constitutional right. And I want to thank every one of the witnesses, all of you, for being here today, most especially Ms. Fulton, Ms. McBath, for your stories and your firsthand experience, which is so profoundly important, because we can have theoretical and rhetorical debates here, but what really matters is what happens to these doctrines of law in the streets, in the courtroom, when they are explained to juries. I say that as a prosecutor. Prosecutors, my fellow prosecutors, would often say to me that the most difficult times for them in prosecuting a case was when the judge tried to explain the law to a jury, right? How do you explain stand your ground in the complex, challenging, often emotionally charged time when a jury has to decide whether a person's liberty should be taken away, and sometimes even a person's life, as a result of the alleged commission of a serious crime? And so I must say, Mr. Laban, your testimony has special meaning to me, because the members of your associations are the ones who take cases, this myriad of facts, sometimes confusing and contradictory, and try to present them to a judge or a jury in a way that results in justice. And you used one word that I think is profoundly important: ambiguity. Stand your ground, as opposed to self-defense. Even as I sit here, I wrestle with what the distinctions are in real life and how they are explained to juries. And that's why I agree with Senator Durbin that the ambiguity of these doctrines can encourage violence and confrontation. The apparent approval that it may give to people who feel that they've been insulted and maybe threatened, non-physically but verbally, seems to me can result in a hope of acquittal or non-conviction, and thereby encourage violence. So maybe you can speak to how in the courtroom this doctrine of stand your ground has a practical impact.
Thank you, Senator. And it's, here I am in front of not one former Attorney General, but actually two former Attorneys General. So I'll have to be real good on my law, especially as you talk about the courtroom. First of all, what this law does is place it as either it's murder or nothing. And you talked about the ambiguity. Someone chooses to take an action and chooses and intentionally kills another. And it usually, in the role of prosecutors with homicide in that killing, is it a manslaughter? Is it a murder? If it is a murder, is it a first or a second? Are there some special circumstances? But when you put this, both the presumption and the immunity provisions in there, you create a situation where it's very difficult to determine, even at the filing stage, what kind of a crime it is. But especially particularly as it relates to Florida, you're put into that box. It's either murder or nothing. Secondly, there's been some discussion here about the aggressor. And I would like the committee to look at Chapter 776.041 of the Florida statute and why stand your ground did apply in the Trayvon Martin case and applied directly. It is because 776.041 says use of force by aggressor. And clearly within that statute, they allowed, and it's the person reasonably believes. So it was a subjective belief by Mr. Zimmerman that he was about in imminent danger that therefore justified his use of that force, which goes directly to what one of the jurors said. And the jurors did, as you talked about the courtroom, the jurors followed the law. The law said you can use that reasonable force under the Florida stand your ground if you believe that you are reasonably in that imminent threat. So it is, yes, it's incredibly difficult, and the ambiguity is never good. The other test that we use with ambiguity is how many appellate decisions come out of a particular statute. All of you know with state legislatures how many criminal statutes get passed, how much end up appealed and get reversed. And stand your ground is one of the most appealed, especially as it relates to the homicide cases. And that's why I say the ambiguity is incredibly apparent. Just look at Nexus if you want to see all the different ways that this has been appealed.
In your experience, Mr. Laban, do the members of your organization overwhelmingly share your view?
They do, and that's why I point to the statement of principles. Also, the difference between the legislative branch as well as the executive branch. My members are the executive branch. Once the legislature steps forward and passes a law, we must do everything we can to try to seek justice in those cases, just like what occurred in Florida. So even with that opposition, they're enforcing it.
In your experience, do the overwhelming majority of police officers share this view?
Again, the officers that I'm working at, the other national associations, yes, some very sincere, and that's why I talked about justified killing an officer. I believe Indiana flips that around and basically encourages, as you talk about the public policy, to go ahead and take an officer's life unless you, as the citizen, believe that that officer was following and course and scope of employment. That to me, again, Senator, that's craziness.
So police officers feel these laws may, in effect, represent a threat to them.
Back to ambiguity, both a threat to them, they might be serving a search warrant, going into a home, what if they're plainclothes, not in uniform, and that absolutely, and I believe a Georgia case is directly on point with that one, that the requirement is that there be actual knowledge instead of an officer doing their job. That's a problem for police officers, and then officers don't know what to do when you have a statute that says you can't arrest, yet you're supposed to investigate. What does that mean?
And I think you say it well in your testimony when you say prosecutors, and I'm quoting, prosecutors, judges, police officers, and ordinary citizens have been left to guess what behavior is legal and what is criminal, which I think hits the point about ambiguity.
And there should not be ambiguity in something like murder, Senator.
Thank you. Thank you, Mr. Chairman.
Mr. Shapiro, I know you have to leave to catch a train. You told us ahead of time. Thank you so much for your testimony and being here today. Senator Graham?
Thank you, Mr. Chairman. One of the observations about this whole debate is how diverse